Neama, great to see you. Let's walk through this burglar theory, okay? And so the way I look at it, if she's out there, Laci Peterson, and she comes across a burglary in progress, and the burglars are like, oh my goodness, we can't get caught breaking into a house, so let's abduct this pregnant woman. Which do you think is more plausible? Do they then hold her for months and then wait until they find out that Scott Peterson, her husband, was fishing in San Francisco Bay and then drive 2.5 hours and place her in the bay then? Or are these burglars just really unlucky and that they, again, had to murder the witness to breaking into a house and just coincidentally discarded her body in the place 2.5 hours away where Scott Peterson just coincidentally happened to go fishing that day?
And coincidentally, Scott Peterson bought a boat 15 days before his wife disappeared and researched ocean currents and couldn't identify any of the fish he was allegedly fishing for. So, look, this is a theory, but it's certainly not a good one. I know the defense has been focused on the timeline in this case and the fact that if Laci Peterson was walking the dog, then it's impossible for Scott to have killed her. But, you know, they're better off focusing on those appellate issues. That's a much stronger chance of success than actual factual innocence because they just don't have that here. This is something that's new in criminal appellate law. We saw it actually in the Boston Marathon bomber case where the First Circuit reversed his death penalty conviction based on insufficient questioning of the jurors. That's going to the Supreme Court. So, I mean, I understand why, even though I don't agree, I understand why the California Supreme Court reversed the death sentence based on the incomplete voir dire or actually exclusion of jurors who did not support the death penalty. But as far as the habeas petition, you know, with respect to juror misconduct, Miss Nice, who, you know, we're probably going to deal with the same issue. And I know we're talking about other cases, but he's going to be sentenced tomorrow. We're going to deal with the same issue in the Derek Chauvin trial. One of the appellate issues was a juror honest when he answered a questionnaire about participating in rallies, and he was in a rally in D.C., and was he participating in a the question was related, at least one of the questions related to Minnesota, but her specific questions were, was she a victim of a crime, and had she been a party to a lawsuit? Well, she had sought a restraining order against her boyfriend's ex-girlfriend. So the judge in this case is going to need to decide, was she being honest when she answered those questions? And this particular juror took it one step further or two steps further. She wrote a book about her experience, and she actually exchanged about a dozen letters with Scott Peterson when he was in prison, which was just bizarre. So I think that is the best defense argument, that, look, regardless of factual innocence or not, this burglar theory, walking the dog, the mailman, you have juror misconduct here. That there you have a specific juror who wanted to get on this jury, who told the court that even though her employer wasn't going to pay for jury duty, she wanted to be on this jury, and she intentionally lied to get on this panel.
That's it, yeah. You know, it was a bizarre deliberation, by the way, also. They reached a verdict on a Friday, but they didn't deliver it until the following week because one or more of the jurors wanted to stay in the hotel for the weekend because they were sequestered during that part, which was fascinating to me. How much of this, and we only have about a minute left here, how much of this, though, is, hey, you know, when you're first trying the case, you've got to investigate it, you've got to figure out, the burglary thing's nothing new here. To me, that's old. If you chose not to do it in the first trial, too bad.
It is too bad. And, you know and I respect Mark Garagos, who was the lead defense attorney in this case. But, I mean, that's not something that you can bring up, 15 years later on appeal. That's not something that you can do. Maybe Peterson has an ineffective assistance of counsel claim, but as far as his defense team is concerned, you can't bring up these facts. That's just poor legal strategy, nothing more. It's not an appellate issue.
Neama Rahmani, always great to have you on the show. Thanks a lot.